Last year, about 38% of the decisions were unanimous. And so that puts a lie to the idea that this court is deeply divided. They are divided, but not on everything. And for the most part, 38% of the time they're unanimous. But if you add in the other very close to unanimous decisions, almost 60% of their decisions are 9-0, 8-1, or 7-2.
So we have these two cases, and there's gerrymandering going on by both Republicans and Democrats, depending on which state you're in. The plaintiffs alleged violations of the First Amendment, the Equal Protection Clause, of the 14th Amendment, and the Elections Clause. And the district courts in both these cases ruled in favor of the plaintiffs, that these particular jurisdictions were both massively politically gerrymandered, and I'll give you some stats on that in just a minute. The Supreme Court, however, decided that it can't decide these kinds of cases. Babb versus Wilkie, which is under the Age Discrimination and Employment Act, this case is all about causation in age discrimination cases. Here, the court is trying to decide what level of causation do you need in order to prove up a claim under the Age Discrimination and Employment Act. So the argument can go two ways on this. One is, if you go with a Justice Roberts approach here, if Congress meant to amend the ADEA to make it just a motivating factors test instead of but for, it could have done so in the Civil Rights Act of 1991. The opposite argument would be Congress sent a clear signal about how it wants employment discrimination claims handled. It did it in the Title VII of the Civil Rights Act of 1964 because that's what was before it at the time. Courts, we mean for you to take this motivating factor test across all of the anti-discrimination laws. So it can be argued either way. If Roberts stays true to course, he's going to tell Congress to go ahead and make it explicit, and I would expect a 5-4 split on that one.